Judicial Officers Association has already strenuously objected to any increase in the retiring age of 60. I suppose after over 25 or 30 years of wandering from one judicial division to another, they probably wish to settle down and enjoy family life. Nor have judges of the Supreme Court ever requested an extension of their retiring age, probably because of the fact that the extremely lucrative world of arbitration is at their feet from the moment of retirement. In addition to receiving 90% of their salary in the form of a monthly pension. There is now a further incentive provided by a recent judgment of the Supreme Court itself that if a retiring judge chooses to draw a commuted pension on retirement, that is an advance payment of a sum equivalent to say 50% of the monthly pension due in the next 24 months, that advance payment cannot thereafter be recovered by the government from his monthly pension, because according to the judgment, 2 judges of the Supreme Court and 1 dissenting judgment, Article 108 of the Constitution states that the pension entitlement of a Supreme Court judge shall not be reduced. That is, after taking a substantial portion of the future pension in advance, the state is nevertheless required to pay him the full pension thereafter. In effect, a loan which a retiring judge is not required to repay. A privilege not accorded to judges of lesser rank or to other members of the public service. This judgment was delivered by 2 judges on eve of their retirement. One dissenting judge. And it was filed as a fundamental rights application filed by a judge who had earlier retired. Now, the first point I wish to make is that it is a fundamental tenet of judicial independence that a judge of the highest court should have a constitutionally guaranteed tenure. It could be for life until the expiry of a retirement age or the expiry of a fixed term of office. That is a guarantee of judicial independence. The retirement age of judges of the Supreme Court has always been determined at the stage of drafting a new constitution. The 1947 Constitution of Ceylon specified that the retirement age of judges of the Supreme Court shall be 62 years. It also stated that the Governor General may permit a judge who has reached the age of 62 years to continue in office for a period not exceeding 12 months. Now, neither Sir Ivor Jennings, who prepared the minister's draft, nor B.P. Peerish, the draftsman of the 1947 Constitution, has taken responsibility for that extension provision. It is therefore likely that it was inserted by the British government having regard to the interests of members of the colonial judicial service who were serving on the Supreme Court at the time when that constitution came into force. In fact, the Chief Justice himself, Sir John Howard, was a member of the colonial judicial service. When the 1972 Constitution was being drafted, it was decided to omit that discretionary power of the government to grant selective extensions of service to judges of their choice, although I am not aware of any such extension having ever been granted. Instead, the retirement age of judges of the Supreme Court was fixed at 63. The 1978 Constitution abolished the Supreme Court altogether, replacing it with a new Supreme Court and a Court of Appeal, and for what Dr. Colvin R. de Silva has described as, and I quote his words, the witcher's cauldron. President Jayawickrama picked out 11 judges, distributed them to 2 appellate courts without regard to seniority, experience or age, excluded 8 judges, and then increased the retirement age of the chosen ones to 65 years and 63 years respectively. That is the position today. The second point I wish to make is that there does not appear to be any valid or credible reason today to freeze the judicial sector by extending the tenure of the Chief Justice, of the judges of the Supreme Court and Court of Appeal, and of the subordinate courts, as appears to be one of the other options the government is considering. Give everybody an extension of 2 years. The legal profession has never been as large in number as it is today. Consequently, the field of selection of new judges is enormous. To extend the tenure of serving judges is not only to deny the legitimate expectation of many at the bar, of many of the judges in service for promotion, but also to frustrate the aspirations of hundreds of young lawyers who seek a career in the judicial service. The failure of the government to fill several vacancies that exist today at all levels of the judiciary compounds this unwarranted interference with the due administration of justice in this country. The third point I wish to refer to is the bizarre argument that extending the tenure of serving judges is necessary to reduce the enormous backlog of cases, many of which have been instituted more than 25 or 30 years ago. This is a spurious argument which I encountered over 50 years ago when we introduced the Administration of Justice laws of 1973 and 75. Litigation is not expedited by establishing more courts and appointing more judges. Litigation is expedited by reforming the procedure. Reference to a conciliation board before proceeding to a court, evidence through affidavits instead of by examination in chief, a pre-trial conference, hearings from day to day with no postponements whatsoever except in the event of a family bereavement, written submissions in the appellate courts and oral arguments limited to 30 minutes as is the procedure in the United States Supreme Court, and the listing of appeals in the order in which they had been filed were some of the reforms which we introduced to expedite civil litigation. Of course, they were not all observed. In fact, the Chief Justice himself told me, I'm not going to have any kind of restriction on timing. They can speak for 6 weeks if they want to in my court. And listing them according to the number that the appeal bears, so that various appeals will be taken up. And we provided 7 appellate courts of 3 judges. He said, no, Mr. Establish Jayawickrama and Mr. Venkatanathan are retained in the same case. They will be in the same court. I don't care about the number that the appeal bears. Similarly, the abolition of non-summary proceedings was just one of many reforms in criminal cases. Research conducted by Dr. Nihal revealed that in 3 years, 53% of civil disputes have been resolved in conciliation boards without the appearance of lawyers and therefore did not reach the courts. Now, the fourth and final point which I wish to make is that during both the presidential and general elections, the NPP promised to abolish the executive presidency and to restore parliamentary government under a new electoral system. That promise remains unfulfilled. On the other hand, if it was intended to extend the tenure of judges of the appellate courts, why was the bill not introduced for that purpose before 8 judges retired a few months ago? If the intention was to extend the tenure of the Chief Justice, why was that benefit not extended to Chief Justice Murthy Fernando, who was appointed by and retired during the term of this government? The constitutional amendment now would lead one irresistibly to the conclusion that what the government seeks to ensure that the present Chief Justice continues in office for 2 more years following the constitutionally mandated date of his retirement. In my view, that would be a blatant interference in the administration of justice in this country. The government's silence is deafening. The Bangalore Principles of Judicial Conduct, endorsed by the UN General Assembly, adopted by judiciaries on all the continents but ignored by the Sri Lankan judiciary, states that the discretional recognition of the judge's judicial work by the executive jeopardizes its independence. Before I conclude, I wish to conclude on a somewhat sober note, not a happy one, but some previous governments have also succeeded in ignoring sound constitutional practice and secured the appointment as Chief Justice of candidates of their choice. For example, in 1955, Sir John Kodalawala secured the premature retirement of Chief Justice Sir Alan Rose 6 years before the due date to enable him to appoint Attorney General Basnayaka to that office. In 1974, Mr. Victor Tennakoon was appointed Chief Justice, superseding 5 judges who were senior to him, in what Justice Minister Felix Das Bandaranaike described to me as, and I quote, a Candian coup. In 1977, President Jayawickrama appointed his own personal legal advisor, Nihal as Chief Justice, ignoring the claim of Justice Jayawickrama, who had by then served 11 years in the Supreme Court. In 1988, President Jayawickrama again ignored the most senior judge, Justice Ranasundara, and appointed Justice Parinda Ranasinghe as Chief Justice. In 1999, President Kumaratunga appointed Attorney General Sarat Silva as Chief Justice, superseding 5 judges who were senior to him when he had previously served 4 months on the court. In 2013, President Rajapaksa purported to appoint the legal advisor of the Cabinet of Ministers, Mohan Peiris, as Chief Justice, following the disputed removal of the incumbent, Sirani Bandaranaike, ignoring the most senior remaining judge on the court. That leaves me with the question, would it not be better option for this government if the President were to find an individual acceptable to him from among the present judges or from the bar to serve as Chief Justice upon the retirement of the present incumbent, rather than violate the integrity of the Constitution?